23,250 pounds. That's the exact figure the government uses to decide whether your family gets to keep your home or whether it gets sold to pay for care. And if you're over 60 and you own your house, there's a good chance nobody has ever explained that number to you properly. You're about to lose thousands of pounds, maybe your entire home, not because you did anything wrong, but because of paperwork you didn't know you needed. And stay until the fifth document, because that one changes completely from April 2027, and almost nobody watching this has updated it yet. I'm Margaret Hale, and I spent close to 20 years working alongside solicitors and financial advisors, helping families sort out exactly this kind of planning, the kind nobody tells you about until it's already too late. Here's the thing nobody at the DWP, HMRC, or your bank is going to do for you. None of these systems ring you up to check your paperwork is in order. They wait, and waiting is expensive. There are 5 documents that decide whether your family keeps what you've spent a lifetime building or loses a huge chunk of it to legal fees, care costs, and tax bills that proper planning would have avoided completely. Let's go through them one by one, and remember, stay for the 5th one, because the rules around it just changed in a way that catches almost everyone out. Let's start with the one costing British families the most money right now, today, this year. Not in legal fees, in care fees. Somewhere between 40 and 70,000 homes in England are sold every single year to pay for residential care. Here's how it happens. The self-funding threshold in England is £23,250 in total assets. Once you're above that, you pay for your own care. Full stop. Residential care runs between £1,200 and £1,500 a week. Do that math over 3 or 4 years. And a family home, the one thing most people wanted to leave behind, gets swallowed whole. Here's who this affects. Married or civil partnered homeowners over 60, especially where one partner is likely to need care before the other. And here's the part almost nobody knows. If you own your home as joint tenants, which is the default most couples never think twice about, the whole property automatically passes to the survivor when one of you dies. Sounds fine until the survivor needs care, and then the entire property, the full value, gets counted in the means test. But if you own the property as tenants in common instead, each of you owning a defined separate share, you can leave your share through your will into a discretionary trust. Structured correctly and done well in advance, that trust share can sit outside the care fee assessment entirely. That's not a loophole nobody's supposed to know about. It's a completely legal, completely standard structure that most homeowners have simply never had explained to them. The action step here is straightforward. Talk to a solicitor this month about severing your joint tenancy and setting up a declaration of trust alongside an updated will. It typically costs a few £100s. Doing nothing can cost you the house. Here's a document that decides whether your own family can even access your bank account when you need them to. A lasting power of attorney gives someone you trust the legal authority to manage your affairs if you ever lose mental capacity. There are 2 kinds, one for property and finances, one for health and welfare, and you genuinely need both. Without one, here's what actually happens. Your spouse, your children, it doesn't matter how long you've been married or how obvious your wishes are to everyone who knows you, none of them can touch your accounts, sell your property, or make care decisions on your behalf. They have to go through the court of protection instead, and that process takes 6 to 12 months and costs somewhere between £3,000 and £5,000. Meanwhile, your money sits frozen. But here's the detail that trips up people who think they've already handled this. Even after you sign an LPA, the Office of the Public Guardian still has to register it, and that currently takes 8 to 20 weeks. Registration itself costs £82 per document, £164 if you're doing both types. If you lose mental capacity before that registration completes, the OPG will refuse to register it at all. A signed but unregistered LPA has no legal effect whatsoever. Starting the process isn't protection. Finished and registered is protection. If you haven't got both LPAs registered right now, that's this week's job, not this year's. And it isn't only about you. If your spouse doesn't have registered LPAs either, the exact same freeze applies in reverse, which means a single household can end up with 2 separate court applications running at once, 2 sets of fees, 2 sets of delays, at exactly the moment everyone involved is already under enormous strain. But what happens if the property side is sorted and the health side gets forgotten? That's more common than you'd think, and it's next. Let me pause here for a second, because this next part catches out people who genuinely think they're covered. Picture Brian, 68, remarried 4 years ago after his first wife passed away. He's got a will. He wrote it years back, leaving everything sensibly split between his children and his current wife. Or so he thought. He's never given it a second thought since the day he signed it, because as far as he's concerned, the job is done. What Brian doesn't know is that his will was written before this marriage. And under English and Welsh law, marriage automatically cancels any will made before it. Not weakens it, not partially affects it. Cancels it completely the moment he said, I do. Brian has, legally speaking, no will at all, and he has absolutely no idea. If something happened to him tomorrow, his estate wouldn't go where he thinks it's going. It would be distributed under the intestacy rules instead, a fixed legal formula that has no concept of blended families, no concept of stepchildren he's helped raise, no concept of his current wife at all, beyond a partial capped share. It has absolutely no idea who Brian actually wanted to provide for, because it isn't looking at Brian's wishes, it's looking at a chart. Here's the uncomfortable part. Brian isn't unusual. He's the median case. Anyone who has remarried, entered a civil partnership, or even just assumed an old will probably still counts, is very likely sitting in exactly the same position right now without knowing it. That's such a common mistake, it's worth its own moment. But let's keep moving, because there's a smaller, quieter document that most people never think to keep, and it can matter more than they realize when it comes to inheritance tax. Any gifts you make while you're alive can affect what your estate owes in inheritance tax later, under what's known as the 7-year rule. Gifts you make more than 7 years before you die generally fall outside your estate for tax purposes. Gifts made within 7 years may still be taxed on a sliding scale, depending on how close to your death they were made. Here's who this affects. Anyone over 60 who's ever given money to children or grandchildren for a deposit, a wedding, school fees, anything substantial. The number that matters here isn't fixed. It depends entirely on what you've given and when. But families regularly lose thousands in unnecessary tax simply because nobody kept a written record of the date, amount, and recipient of each gift. The action step is almost embarrassingly simple. Start a written log today. Every gift, every date, every amount, kept somewhere your executor can find it. It costs nothing, and it can save your family a genuine argument with HMRC after you're gone. Now back to the will itself, because Brian's situation isn't rare. It's the single most common and most avoidable mistake in estate planning in this country. Around 60% of UK adults don't have a valid will at all, and marriage revoking an existing one is a huge part of that number. Under the intestacy rules, unmarried partners get nothing automatically, no matter how many decades they've lived together. And in blended families, where you want to provide for a current partner while making sure children from an earlier relationship still inherit, the intestacy rules produce results almost nobody would have chosen on purpose. If you've remarried or entered a civil partnership since your will was written, check today whether it's still valid, because the answer is almost certainly no. This is the one I told you to wait for. Your pension does not pass through your will. It passes through something called an expression of wish form held directly by your pension provider, completely separate from everything else we've talked about. If you filled that form in 20 years ago and named an ex-spouse or a parent who's since passed away and never updated it, your pension provider may still pay out to that person, regardless of what your current will says. Here's why this matters so much more than it did even a year ago. The Finance Act 2026 confirmed that from the 6th of April 2027, unspent defined contribution pension pots will be pulled into your inheritance tax estate for the first time ever. Until now, pensions passed to beneficiaries completely free of inheritance tax. From April 2027, anything above your available nil rate bands gets hit with the standard 40% charge. That means your expression of wish form now carries both a beneficiary risk and a brand new tax consequence. And most people's forms are years out of date. The action step: contact every pension provider you've ever paid into, active or dormant. Ask for your current expression of wish form and update it in writing to reflect who you actually want to receive that money and how the new tax rules affect your overall plan. This one genuinely surprises even people who think they're financially switched on, because for decades, the advice was the exact opposite. Keep money in your pension for as long as possible, precisely because it sat outside your estate. That advice is now out of date. From April 2027, it may actively work against the people you're trying to protect, depending on the size of your pot and what else makes up your estate. This isn't a reason to panic and empty your pension tomorrow. It's a reason to sit down, look at the whole picture together: your property, your will, your pension, your gifts, and make sure they're all pointing in the same direction instead of quietly working against each other. So here's where this leaves you. None of these 5 documents cost much to put right. A declaration of trust to protect your home from care fee assessment. Registered lasting powers of attorney so your family can actually act for you if they need to. A written record of any gifts you've made for the 7-year rule. A will that's actually still valid, especially if you've remarried. And an up-to-date expression of wish form on every pension you hold before the April 2027 changes land. Put together, sorting all 5 typically costs a few hundred to a couple of £1,000s. Getting even one of them wrong or leaving it undone has cost families their home, their savings, and money that went to entirely the wrong person. If you know someone over 60 who owns their home, send them this today. It might be the thing that saves their family a genuinely enormous amount of money. And subscribe, because the April 2027 pension changes are just the beginning of a wave of rule changes coming for homeowners over the next few years. And you'll want to know about the next one before the deadline hits, not after. The paperwork sitting in your drawer right now is either protecting your family or it's a ticking clock. Only one way to find out which. I'm Margaret Hale. I'll see you in the next one.